Hello and welcome. In this scholarly review, we're going to unpack the landmark cases that have truly shaped India's Code of Civil Procedure, what lawyers call the CPC. Understanding these judgments is absolutely essential, because they lay the groundwork for how our entire system of civil justice actually functions. So let's dive right in.
Now, before we get into the nitty-gritty, it's crucial to grasp the core philosophy of the code itself. And this quote from the Supreme Court in Sangram Singh versus the Election Tribunal says it all. The big takeaway here is that the CPC is meant to be a tool to help deliver justice, not a weapon to punish people with. Its whole purpose is to aid justice, not to get tangled up in technicalities that would block it.
All right, here's our game plan. We've broken this down into 5 key areas. We'll start with the spirit of the code. Then we'll get into some key legal definitions. After that, we'll tackle the huge topic of court jurisdiction, look at the transfer and stay of suits, and finally, we'll wrap up with the absolutely critical doctrine of res judicata.
Okay, let's kick things off with our first section, the spirit of the code. You'll often hear this beautiful phrase, procedure is the handmaiden of justice. And what that really means is that procedure is the servant, never the master. Its job is to support and facilitate the ultimate goal, which is always a just and fair outcome.
So this philosophy isn't just a nice idea. It's built on solid judicial principles. That Sangram Singh case, for instance, established that the rules have to be interpreted liberally in a way that helps justice along. It means that simple technical objections can't be used to defeat a person's legitimate claim. Building on that, the case of J.J. Ram Manohar made it clear. You can't deny someone relief just because of a small procedural slip-up. And, maybe most importantly, Maharlal versus Setharalal confirmed that courts have inherent powers. This means they can step in and do what's necessary for justice, even if there isn't a specific rule covering the situation. Moving on to our second section, here we're going to look at some key legal definitions. Think of these as the fundamental vocabulary, the absolute building blocks of any civil lawsuit. You really can't understand the process without getting these terms right.
First up, the cause of action. Now, the definition from the Southeast Asia shipping case is fantastic. It calls it a bundle of facts. It's not just one single thing, it's the entire collection of essential facts that a plaintiff has to prove to win their case. It's the very foundation, the reason they're in court in the first place.
Next, we have the decree. This is a really important one. A decree isn't just any old order from a judge. It's the formal, final judgment of the court. It conclusively settles the rights of everyone involved in the dispute. Once a decree is passed, that particular court has spoken its final word on the matter. But, and this is a key distinction, decrees can actually come in 2 stages. As the case Renu Devi versus Mahendra Singh clarified, you can have a preliminary decree and a final decree. Think of it like this. A preliminary decree is like the architect's blueprint. It declares what everyone's rights and liabilities are. A final decree, on the other hand, is the finished building. It comes later and actually puts those rights into effect, bringing the lawsuit to a complete close.
We now arrive at our third section, and it's a big one. Understanding court jurisdiction. You could argue that this is the most fundamental concept in the entire field of civil procedure. It all comes down to one thing, the court's basic power to even hear a case.
And that leads us to this central question, doesn't it? What is it that actually gives a court its authority? Where does its power to summon people, hear arguments, and issue judgments that everyone must follow? Where does that actually come from? Well, that's the whole idea behind jurisdiction.
And the importance of getting this right is just hammered home in the case of Kiran Singh versus Chaman Paswan. The Supreme Court was crystal clear. A lack of jurisdiction isn't some minor technical problem. No, it strikes at the very authority of the court. Any judgment, any decree passed by a court that didn't have jurisdiction is a complete nullity. It's legally void. It's as if the lawsuit never even happened. That's why this is so critical. Okay, but it gets a little more nuanced. The case of Hiralal versus Kalinath helps us draw a really important line. On one hand, you have an inherent lack of jurisdiction. This is a fundamental problem, like a traffic court trying to decide a patent case. It just can't be done. On the other hand, you have a lack of territorial or pecuniary jurisdiction. Basically, the case is in the wrong city or it's about too much money for that court. This is seen as a technical defect. And here's the kicker. If the defendant doesn't object to it right at the start, they're considered to have waived the issue. All right, let's move on to our 4th section. Here we're going to look at the tools the code provides for managing the litigation process itself, making sure everything is handled as fairly and efficiently as possible. This is all about where and when a lawsuit is tried. So first we have the doctrine of res sub judice, which you'll find in section 10. The name literally means a matter under judgment. And its purpose is really straightforward, is to prevent total chaos. You can't have two different courts trying the exact same case between the same people at the same time. This doctrine stops that from happening. It avoids conflicting decisions and just a complete waste of everyone's time.
So, how do you know when to apply this rule? Well, the test, which was laid out in Radhadevi versus Deep Narayan, is quite elegant. A court just needs to ask itself one question. If a final decision were reached in the first lawsuit, would that decision block the second lawsuit because of res judicata? If the answer to that is yes, then the trial of the second lawsuit has to be put on hold or stayed.
Next, we have the court's power to transfer a suit from one court to another, which comes from Section 24. Now, as cases like RV Industries and Indian Overseas Bank make very clear, courts do not take this lightly. They use this power with extreme caution. The real job here is to find a balance between the plaintiff's right to choose where they file suit and the court's duty to make sure both sides get a fair trial. And a huge part of that calculation is the balance of convenience, what's most practical and fair for the parties, and importantly, for their witnesses. And that brings us to our final and arguably most powerful topic, the doctrine of res judicata under Section 11. The name literally means a matter decided, and its whole purpose is to make sure that at some point litigation comes to a final, definitive end. So let's put these two doctrines side by side because it's so important to see the difference. Res sub judice, which we just talked about, is like hitting the pause button. It bars the trial of a second suit from going forward. But res judicata is like hitting the big red stop button. It's more absolute. It bars a second suit on the same matter from even being filed in the first place. One pauses, the other prevents. So why have such a powerful rule? The thinking behind it was explained perfectly in Satyadan Gosal. It's all based on public policy, on the fundamental need for judicial decisions to be final. There has to be an end to litigation. Once a court has made a final call on an issue, the same parties can't just keep fighting about it over and over again. It ensures certainty. Now, this doctrine has a very clever extension called constructive res judicata. As the Workman case explained, this principle says that you're barred not only from relitigating what was decided, but also what might and ought to have been raised the first time. The point is, you have to bring your whole case at once. You can't hold an argument in your back pocket, and then if you lose, try to start a whole new lawsuit based on that argument you saved. You get one shot. And finally, the doctrine can get even more complex. It can sometimes apply between co-defendants, people who are on the same side in the first lawsuit. But for that to happen, the case of Iftikhar Ahmed laid out 4 strict conditions that all have to be met. 1. There had to be a real conflict of interest between them in the first place. 2. The court had to actually decide that conflict to be able to give the plaintiff their relief. 3. That question between the defendants was finally decided. And 4. They were proper parties to that first suit. Only if you can check all 4 of those boxes will the decision stop them from suing each other later.
So, as we wrap up, we come full circle to where we began. All of these landmark cases show the courts constantly trying to balance these important procedural rules with the ultimate goal of achieving substantive justice. And that leaves us with a profound and ongoing challenge. If procedure is truly the handmaiden of justice, how do we, as a legal system, ensure it never, ever becomes the master?